All right, welcome to the discussion of the water resource. That is Block 10 of our materials. And my guest for this segment of the water resource is Carlos Ronstadt. I've known Carlos and his family for a long time. And those of you that are familiar with the Ronstadt family know of the long association with southern Arizona. So we're going to talk about the historical rights, water rights in Arizona, and then we'll go on to the surface groundwater dichotomy that we have under Arizona water law, and then get into the Arizona stream adjudication. We'll then talk about the reserved water rights, and I see that we have another major segment of the Arizona stream adjudication. But finally, we'll wind up this segment with a specific discussion of the law of the Colorado River that will be done by Professor Robert Glennon. But the first thing that we need to talk about and relate this back to the area around Tucson. This is a drawing from the book on the boundary survey that was done by the Boundary Commission of John Bartlett, who operated between 1850 and 1855 to draw the boundary line of Arizona, or actually New Mexico territory at the time. And within this image, you can see right beneath us is the old convento and the mission gardens. Now, this whole area of these agricultural fields beneath a mountain is really critical to one of the first cases that we'll talk about. And I think you have to keep in mind too is the at the bottom of the image here it says Tucson, Sonora, because at the time of the Boundary Commission, Tucson was indeed in the Mexican state of Sonora. The Santa Cruz River itself flows from the south to the north, and it goes by, or it rises to the surface around Martinez Hill on the way down to Nogales. That's where there's a bridge across the river, and you can see Martinez Hill over on the east side of the river there. And then it also rises to the surface around Sentinel Peak, a mountain, and you can see towards the north of that image San Agustin Mission and the Mission Gardens. The reason for this is based largely on geology, and you can this is the area that shows the Tucson Mountains that created the bedrock high that rise, or that allows the river to rise to the surface. And these are the agricultural fields that are at the base of a mountain. This was from the 1862 map by Major Ferguson that formed the basis of a lot of the, it finally formed the basis of some land grants in the area of these small parcels that most of them were not patented until the 1890s. But you can see on the left side of the map there are Mission Gardens, and then a little bit further to the south the convento and the mission itself.
And north is to the right of the map.
Yeah. I think it's a bit deceptive when you look at those images at the top. Those spears coming out. Those would be the north arrow and true north and magnetic north. But I think that the first case I'd like to talk about is Dalton versus Renteria. And one of the reasons, this is a really historic case, but I think that it also relates to Carlos, because Carlos's middle name is Dalton.
Yeah, and that W.A. Dalton, Winall Dalton, was my great-great-grandfather. So he was the Zanjero for some of those ditches. And that case came about, if on the preceding map, it was dated 1862. And at that time, most of the land that's depicted there, I think they were called huertas maybe, I'm not sure I've got the right word, but they were small tracts of land primarily used for subsistence farming, but especially after the Civil War ended, when you had a lot of soldiers from the Civil War coming out into Arizona to seek their futures, and also a lot of Mexican entrepreneurs like the Carrillo family. The pattern began to change as Tucson became larger. They needed vegetables. And so a lot of these fields in this map, I'm not sure where St. Mary's Road is or would be on this map.
St. Mary's would be right to, well,
probably
I
off
think
the map.
But not too far off
Right.
the map on the right side. And one of the things that I've always enjoyed is if you take this map and the general land office map that was created from this map, and overlay that on the USGS map, current USGS map, St. Mary's Road is in exactly the same spot.
Yeah, it hasn't moved.
Yeah.
Yeah. So anyway, these lands were acquired by Carrillo and Sam Hughes, and it seems to me there was one other person, maybe Davis. And some of these lands were then leased for the Chinese gardens. There was about 150 acres that all of a sudden was intensively irrigated. And when that happened, the mostly Hispanic farmers to the north of St. Mary's Road found themselves shorted, and the Carrillos, the Hugheses, and the Davises told the Zanjero at that time to not give those Hispanic farmers on the north side of St. Mary's water. Mm-hmm. And they said the only time they're entitled to water is surplus, when there's a surplus. And they kind of cited, at least at the trial court, prior appropriation. But when it went up on appeal to the Arizona Supreme Court, they looked at the fact that that water had been shared equitably for at least 16 years, maybe longer. And so in my mind, this case has always been an equitable apportionment, kind of affirmed the way that the acequias, the irrigation ditches, were operated at that time. And kind of, they didn't disparage prior appropriation, but they certainly didn't pay too much attention to it when they were ruling that everybody north or south of St. Mary's Road had a equitable share of that water. If you read that opinion towards the end of it, there's a line about, how evil it is to take a crust of bread from your starving neighbor's mouth. And I've always, that's been with me for 35 years. So.
Now, the part of the problem there too was it Solomon Warner that raised the dam to create Silver Lake?
Right. So he raised the dam, and that further depreciated the quantity of water that flowed on down. Warner, incidentally, gave his great-great-grandson a legacy. This is true. Mm-hmm. You may not believe it, but it's true. He was a merchantman, and he had maybe one of the first in Tucson to bring, I think, goods from California, but he packed away a pair of size 44 Levi's in a cedar trunk. Mm-hmm. And 120 years later, his great-great-grandson opened up the cedar trunk, and here's a mint pair of Levi's, never worn, and he sold it for $100,000.
Yeah, well, that's... If you watch some of the TV shows these days, you can see that those early Levi's are worth quite a bit.
So you know what I do, don't you? I go to Home Depot, or not Home Depot, but J.C. Penney's. I buy Levi's, and I'm putting them in cedar chests for my great-great-grandkids.
Oh, very good. Well, this is an image of what Silver Lake looked like, and it lasted a little while
Right.
in terms of being a recreational spot in the middle of the desert until the next flood on the Santa Cruz River, and that was the end of
Right.
Silver Lake. But you can see that's a mountain in the background, and Solomon Warner's Mill was at the bottom of a mountain. But the holding in Dalton versus Renteria is here that in essence, what you said, that the parties had acquiesced to this equitable and equal distribution of the water.
The funny thing about Dalton to me, I mean, the case is interesting, but in 2 Arizona, there's 3 or 4 other water cases, and at least 2 of them, maybe 3 of them, really cling to the doctrine of prior appropriation. So to me, there's always been an interesting dichotomy between the operation of an acequia over here in the Dalton case, and then in the Lenormand case and maybe one other, they're talking about prior appropriation, and it's almost like, there's not a lot of coordination, even though the justices are the same.
Do you think part of that may have been because of the historic use
Yeah,
within those agricultural fields?
That's why I think Dalton is more of what I call an equitable apportionment, or maybe equitable estoppel would be a better word, because of the failure of Carrillo and others to object to the downstream water use, even though, they're sitting there watching them build ditches and electing the Zenderos and working with both the Hispanic irrigators and their neighbors to clean out the ditches every year, and just doing all the things they were required to do. So I think it's more of an equitable estoppel case.
Yeah, and when you go back to the history of those areas, the fields were clearly there when Father Kino arrived, and probably were there for could have been 1,000 years before that.
That's right.
Just because of the suitability of that particular area to irrigation.
It's the only place there was water.
Yeah.
Permanent water.
Well, what we're going to do in going through this sort of the history of Arizona water rights is to talk initially about the riparian doctrine, and then get into the emergence of this idea of prior appropriation, and we'll touch on a couple things that relate to that, at least in terms of public land development. One is a public right-of-way, or a statute that creates a public right-of-way for ditches and canals. And we'll also mention briefly the Desert Land Act of 1877. That was really one of the Homestead Acts that was designed to allow farmers to perfect their homestead by bringing water to the homestead, and that was the Desert Land Act that was passed in 1877. But the riparian doctrine is this common law concept, and this is the concept that the owners of land adjacent to streams and lakes have a right to use the water. And I think that the problem really comes in there is when you get into consumptive uses. The main idea was that the water was used for power, and it was used you put your paddle wheel for your mill, and you could use it for various purposes. You could run it onto your fields, but the whole idea is that the water was returned to the watercourse. And as we indicated on the slide, the real issues there was what land is considered riparian, how can the water be used, how much water can be used, and who has a right to enforce a riparian landowner's right. We have a comment here from a Colorado versus Kansas, a Supreme Court case in 1943, and their comment here is sufficient here to say that the rights of riparian proprietors are, to a great extent, mutual or correlative. so that the use of the stream or water by each proprietor is limited to what is reasonable, having due regard for the rights of other riparian owners above, below, and or on the opposite shore. So I think that now we've gone through the riparian rights. I think that for those of us that live in Arizona,
you don't have to worry about it, because there's only one line about water in Arizona's Constitution.
Yeah.
And it says there aren't any riparian rights in Arizona.
Right.
So if you're here, you don't have to worry about it. If you go to maybe the Pacific coast or obviously back east, then it's an issue.
Well, the water is plentiful.
Right.
And then it's used mainly for power. The concept of prior appropriation that we have in Arizona is a Western U.S. doctrine that really goes to the establishment in the mining camps in California, and usually the case that people cite for the basis of it is this Irwin versus Phillips, decided by the California Supreme Court in 1855, and this was between two miners who were diverting water by a canal for mining purposes. And the decision stated that among the most important rights of the miners here to be protected in the possession of their selected mining claims, and the right to use those who by prior appropriation have taken the waters from their natural beds and by costly artificial works. And I think that what they're talking about, there's typically the miners would construct these
flumes,
laterals and flumes that sometimes go for miles.
Yeah, diversion dams. It's not limited to just the ditches, but yeah. So it's really, again, it starts out as kind of an equitable doctrine that says that, look, if somebody's there before and using the water before you get there, you take subject to that improvement.
Right.
So it's really not too much. There's not a lot of difference between a mining claim and the treatment of water when it's appropriated.
Right.
So it's pretty easy to see where that came from.
So in Arizona, when you get back to the Territorial Bill of Rights that was enacted in 1864, they in essence say that all streams, lakes, ponds of water capable of being used for the purposes of navigation or irrigation. I'm not so sure why they were concerned about navigation at that point, were declared to be public property, and no individual or corporation shall have a right to appropriate them exclusively to their own private use, except under such equitable regulations and restrictions as the legislature shall provide for that purpose.
And that's from the Howell Code.
Yes.
And the Howell Code also had, I think it's Chapter 55, which was, I don't want to say borrowed from New Mexico, because Arizona was part of New Mexico. So I think when William Howell wrote the Howell Code, all 400 pages of it in 90 days, he plagiarized a lot of that from the earlier New Mexico legislation. And I've never verified that kind of on a word-for-word basis, because my copy of that is in Spanish, and I've never sat down to translate it. But a lot of the same concepts and provisions that are in Chapter 55 of the Howell Code I can find in the New Mexico statutes from 1851, 1852. And then, but those concepts, maybe we're going to talk about this, but those concepts kept rolling over from code to code.
Yes.
So I think there was a code, maybe the Hoyt Code of...
Yeah, the Hoyt Code was 1877.
1877. You find a lot of the same concepts. The public ownership of water, I know, was in there. The prior appropriation, I'm not sure that was in the New Mexico one. Mm-hmm. That may have been something that came out of Howell's efforts to look at some of the cases like the Irwin case that we talked about.
Well, the permit system that was finally established here in Arizona came out of the 1919 Water Code, and that's the one that talked about the the sources of supply. And what they did here was to say that the water that was flowing in natural streams, canyons, ravines, or other natural channels, or in definite underground channels, would be subject to beneficial use,
Right.
as provided.
And that changed the system from going out and posting a notice, recording it in the county, maybe filing a copy of it with I think the Secretary of State.
It was the Secretary of State, and those records were in the attic of the state capitol
if
for
you can
years
find
and
them.
years.
Right.
Yeah.
So it changed that to a system that was first adopted in Wyoming by Elwood Mead, who's Lake Mead's named after him. So you ended up with having to file an application to appropriate. And then once you filed your application, the state would do some due diligence on your application. They'd determine whether it conflicted with other rights, or whether there was a health and safety issue or public welfare. Then they'd give you a permit, you could build your infrastructure, and then once you did that, there was another kind of process of review by the state, and then you would get a certificate. So you went to in Arizona, the application, the permit, and the certificate. And it really did fundamentally change the way that water was appropriated, from being the appropriator having to take certain steps to putting a lot of that on the state of Arizona. And I think at that time it was a water commissioner, but at times it's been with the state land department. Now it's with the Department of Water Resources. But that basic system really hasn't changed since 1919.
Yes, so that's, and I think that's always been one of the big issues that has been raised over the years, or really lately, for rights that were established prior to 1919. Right. And the big issue there is that under the 1919 statutes, if you don't use your appropriation for 5 years, it may be subject to forfeiture, whereas prior to that,
right.
that forfeiture provision was not there.
And that's been an issue in globe equity especially.
Yeah. Well, the big issue that we've had between surface water and groundwater, you'll notice that in the language here we talk about water flowing in definite underground channels, and it's always sort of been amusing to me to see what the law regards as a definite underground channel. As to appropriation of surface water.
And there's not a lot of case law in Arizona on that. There's I think it's the Proctor case from maybe south of here, where they did, for whatever reason, find an underground channel, but most of them have said, look, it's percolating. If it's water you find in the pores of the soil of the earth, then it's going to be treated as groundwater, percolating groundwater. If you can walk across the face of the earth and you can step in it, then it's treated as surface water. So very early on, from the early 1900s, we had a bifurcated system. And I remember, every now and then I'd teach courses or give seminars on water law when I first got out of law school. And I remember being very comfortable with that and just telling people, oh, don't worry about what happens if you pump a well and it depletes a stream, because you're pumping percolating groundwater. That was wrong. But fortunately, most of my clients didn't listen to me, so I guess I'm okay.
But I think that the real issue would be when you get back to that original map that we have showing the Santa Cruz River. That was a natural river course that was flowing north and rose to the surface on an occasional basis, and there it was appropriated at the surface, and you can certainly see that if you put wells down.
And what happens if you put a line of wells along a river and you turn them all on and the stream dries up?
Yeah.
So that's been one of the central issues in Arizona's adjudication process, is trying to answer that question. And when I was involved in the adjudication kind of on a daily basis a long time ago, probably as, I'm trying to remember the dates, but maybe the late 1980s.
Yeah, I think
That's when we had the first series of hearings, and those, all of that hearing, it's finally culminating in some sort of decision, although I don't think it's going to be very easy to implement.
Yeah, well, we'll talk about the Arizona stream adjudication as we go along here. But what we've had is the early cases. There was a presumption that water beneath the surface is percolating, as you told your clients that
Right.
of that assumption, and that the percolating waters were the property of the owner of the soil.
Yeah, there you've got the Howard v. Parent case.
And we're talking about the overlying land being the owner of the soil, and one of the questions here is that the subflow, which is talked about in the statute, it would be those waters which slowly find their way through the sand and gravel constituting the bed of the stream or the land immediately adjacent to the stream. And this land is subject to appropriation, or this water is subject to appropriation.
So we all read the term subflow very narrowly 30 years ago, 40 years ago. And in the Southwest Cotton case, which you've cited up there, that was a little bit, it was kind of, things were kind of flipped around. It was a case of a bunch of well owners suing a surface water appropriator for basically cutting off water that would otherwise flow down the channel, recharge the aquifer, and enable them to, pump more water from their wells. So the court in Southwest Cotton came up with this subflow test, which, when you pump it, does it directly and appreciably diminish the flow of water in a stream? And so we always thought that was a fairly direct, like a one-to-one correlation between pumpage and stream flow depletion. And that concept probably lasted for 50 years until the 1980s in the adjudication process.
The two cases that show sort of a flip-flop
Right.
on this whole question were Brister v. Cheatham, and it was one case where the Supreme Court decided in 1952 where the Arizona Supreme Court initially overruled Howard v. Perrin and held that prior appropriation applied to groundwater based on language in the Desert Land Act, and I'll quote you that language as we go along. But one of the justices retired, and
got a new court.
They got a new court. They applied for a rehearing, and the decision was reversed, primarily to protect the property rights that were acquired on the faith of the court's announcement of the law in Howard v. Perrin and Maricopa County Municipal Water Conservation District.
And Southwest Cotton was primarily a case about the relationship between a surface water appropriator and a groundwater user. Brister v. Cheatham answered the question after it took 2 tries, but is there an appropriative right to groundwater as between competing groundwater pumpers? So, there you had 2 well owners who went at it, one claiming, hey, I was here first, you're drying up my well by pumping. And initially the court said, no, it's prior appropriation. And apparently that raised such a stink that after that justice retired, there was a rehearing. As you said, they reversed it. So we still protected our bifurcated system.
But I think that as between the competing groundwater owners,
It's doctrine of reasonable use.
yeah. So I think
so
that
you can pump and use it to your heart's content. I've always wondered whether there's a difference between the groundwater, the doctrine of reasonable use, and beneficial use under the surface water code, but I've never gotten an answer to that.
Yeah.
But presumably there's cases out in New Mexico, the Erickson case, says you can't waste it, right? You can't just pump it and dump it out on the ground. You can't use it to flood your field to kill off all the gophers. If it's an artesian well, you got to cap it.
Yeah.
You can't just let it run. But so those aren't reasonable uses. But they're also not beneficial uses.
Yeah.
So.
The Desert Land Act that is referred to in Brister v. Cheatham, this is the one that says the waters of all lakes, rivers, and other sources of water supply remain and held free for the appropriation and use of the public for irrigation, mining, and manufacturing purposes. And so I think that this is the catchphrase that the Supreme Court relied on to say that prior appropriation is going to be the rule of the day, as it were.
That's correct.
Now, I think that it certainly became apparent after a while because of the limited amount of water we have in Arizona that water was within the groundwater basins was being depleted, and so in 1948 a groundwater code established critical groundwater areas to try to control pumping within some of these groundwater basins that were being depleted, and it was modified in 1953 to establish restricted areas that prohibited new agricultural development using groundwater in these critical groundwater areas. 1954 laws also prohibited new wells for irrigation purposes in these restricted areas. But this all came down to the negotiation of a groundwater management code in 1980.
Yeah, a lot of this is driven by conflicts. So in 1948, you have a lot of people coming, they're coming to Arizona after World War II, and they want to grow cotton. And there's already a lot of established cotton farmers there, including my grandfather, who incidentally didn't agree with a lot of this. But so the solution that a lot of the people that were already there had was, well, let's just preclude them from irrigating new lands. So that's how you had the development and adoption of the very first groundwater codes in Arizona. But by 1980, the conflicts had shifted from farmer versus farmer to farmer versus municipality or farmer versus mines. And so there was a series of cases that led up to the 1980 Groundwater Management Act. The Jarvis case is probably the one that's most cited, and that's actually 3 cases. But
yeah, and the Jarvis Code was one where the city of Tucson was pumping water in Abra Valley,
taking it off,
moving it out of the basin.
That's right.
For Tucson municipal purposes.
That's right.
And that established a principle that, well, if you could retire agricultural lands,
that was the second or third Jarvis case. That's right.
You could take that amount and take it away from the overlying land.
So the end result is that Tucson could take the consumptively used water across the basin boundary, use it in Tucson, but they didn't have kind of a free hand to drain the basin. Mm-hmm. And then, so all of those cases, Farmers Investment Company, the Jarvis cases, they led to the 1980 Groundwater Management Act. And on that preceding slide, you had that it's kind of a permit system, but also initially they went out and DWR did an amazing job.
That was the Department of Water Resources.
Right, of inventorying and cataloging and characterizing and quantifying all those rights. So when I first got out of law school, one of the things that I did was fight with the Department of Water Resources over those quantifications for all these different, mostly agricultural clients. But when you back away from it and you think about going into, Tucson and Phoenix and Santa Cruz County and Prescott and quantifying all that stuff, the Department of Water Resources did just a remarkable job. You know, inventorying all of that stuff, no computer work at all. I mean, most of it was before you had CAD systems and Google Earth. And so every day, not every day, but every time you or I look up an irrigation grandfathered right, we're the beneficiary of some of that work that was done in the early days of the groundwater management code.
So under the groundwater code here, individuals were required to file their claims to water usage and to put those into the system, whether it was an agricultural use, a mining use, and
they got a certificate.
Yeah.
After a quasi-judicial process.
Yeah. And the final, well, one of the results of the groundwater code was the establishment of these active management areas that were primarily the areas that were seen as being in an overdraft area. And this is a map that shows both the active management areas and also the irrigation non-expansion areas that where new irrigation uses are prohibited. So what we wind up is a system here of controlling the groundwater withdrawal within these active management areas. And this image here is one that you find in the reports of the Arizona Department of Water Resources. And the date here looks like it's 2016. You know, that's the question is, does this really show success?
What it really shows is the urbanization of farmland in Arizona.
Yeah.
That's just my opinion. But when you take out an acre of cotton, you generate 3 or 4 acre feet of water. And so you convert that to subdivision, 4 homes to the acre. You know, you've gone from 3.8 or 4.0 acre feet per acre to 2. And so is this area in this, well, Salt River Valley, I forget I'm in Tucson, but is the Salt River Valley and the Tucson Basin urbanized, a lot of those water uses were cut back or curtailed on that land.
Yeah.
So we have had some success. I don't want to diminish that, but it's not. When you look at this graph, it's really a reflection of the fact that we're growing people now, not cotton.
And when you travel in East Phoenix and in Gilbert and Chandler and areas to the south of that, you can see the shift from farmland to housing subdivisions.
That's right.
Yeah. Well, I think that I mentioned a little bit about the, in the context of the public lands too, is the rights of way, and I think that I wanted to mention this simply because that you have to recognize the fact that you do occasionally find rights exercised in the idea of prior appropriation, where you have to transport waters from a stream across the public land. And this was a statute that was issued in 1866, which is also relates to the rights of way over the public land for transportation that allows you to, in addition to construct public highways, also to construct canals for delivery of water. And the language here that's highlighted as a right-of-way for the construction of ditches and canals for the purposes aforesaid is hereby acknowledged and confirmed. Now this is different from the patent reservation for ditches and canals constructed by the authority of the United States that you find in all patents.
But I think the patent reservation may have been this, or it may have been the
that was in
1897.
1897 that one.
But you see in patents, just the standard language as if there's a ditch or a canal issued under that language.
Yeah.
I guess I shouldn't point at it.
Well,
That's rude.
It's there.
Anyway.
Let's talk about one of the big issues that you see
Right.
these days is on federally reserved rights. And this sort of crosses the both in terms of appropriation and what the appropriative statutes and the groundwater rights are all sort of wrapped up into this one.
So Winters was a Montana case way back when, in 1908, I guess. And basically there was an Indian reservation, I think it was the Fort Belknap Reservation. And upstream non-Indian farmers took the water out of the Milk River, and the United States said, hey, you're drying up our Indian irrigation projects. And the result of that was the Winters opinion, which basically says that when the United States makes a reservation of land for a specific purpose, inherent in that reservation is the intent by Congress, implied usually but not always, that the water sufficient to meet the purposes of that reservation, they're also reserved. And the date of the reservation is, or the date of the priority for that water is the date of the reservation. So it's kind of a way of working in this concept of getting water to federal uses under the doctrine of prior appropriation. I've always thought that it was kind of a subset of prior appropriation because you have all the elements. You have, at least you have the priority date, and you have some way of managing the dispute between, in this case, Indians and non-Indians.
So the priority date would be normally the date of creation of the reservation.
Right.
Yeah.
So then and Winters just sat there for a long time. There were some cases leading up to it, but really there wasn't a lot of litigation under Winters for, I don't know, maybe 50 years. And then all of a sudden, beginning with Arizona v. California, you had 4 or 5 cases that are all pretty important, addressing different elements of the Winters rights or Federal Reserve rights.
Yeah, and that was the 1963 Supreme Court case was sufficient for future requirements of national forest, recreation areas, and wildlife refuge established either by legislation or executive order.
So one of the questions out of Winters was, well, great, we've got a congressional act approving a treaty. What about an executive order? That's not an act of Congress. And in Arizona v. California, they said, hey, if you've got an executive order, and I think Capert may also be an executive order case, but...
Yeah, that was a national monument which would have been created by executive order. So
if executive orders also have inherent in that order the implicit reservation of water. Another aspect of Winters that's not on your slide, in Arizona v. California, it was the first time they really talked about quantifying that right. And for an Indian tribe, at least, it's the PIA, or practicably irrigable acreage, which, and it's not limited to today, it's kind of now and in the future. So when you think about a large, flat Indian reservation like the Gila River Indian Community, that's an incredible amount of water that can be reserved. So Arizona v. California, I mean, it dealt with a lot of the issues that arose under Winter. And then the other cases, Capert, you know, that extended it to a national monument. That's the pupfish case. So when I used to drive around Nevada in the 70s, I'd always see the bumper stickers, you know, save the pupfish versus to hell with the pupfish. And then 2 others that aren't up there, if I can remember them. One is U.S. v. New Mexico, which basically said, yeah, you have a reserved right, but it's the minimum amount that's required to meet that purpose. And they went on to talk about the national forests. And it seems to me I'm missing one other one, but it doesn't make any difference because you're on the next slide.
But, well, we can always switch back. But one of the interesting things that we faced was a question that was raised in the general stream adjudication.
Right.
Was a question that was raised by the states that said, hey, we have all of this land that was granted to the state of Arizona
Is
or
that
the
a
state of New
reservation?
Mexico for purposes of supporting certain institutional beneficiaries. And so do we get
The same treatment.
Right, and the courts in both Arizona and New Mexico
Said no.
in essence said no, and the idea here is, yes, that water was, or that the land was available for the benefit of those institutional beneficiaries, but the idea was that individuals had to establish rights to that land, and so once it went into private ownership, then those private owners had the right to initiate whatever water rights they could based on
Yeah, in your
the
slide,
rules.
in your slide, I was laughing at the slide when I first looked at it. Is there a distinction between a withdrawal and a reservation? And I've always said yes to that question.
Yeah.
Where a withdrawal takes land out of the public domain, so you can't enter upon it to do something.
Right.
Pick the something.
Whereas a reservation sets it aside for a specific
Exactly.
use.
So reservations, it's much easier to say, hey, inherent in that there's this implicit reservation of the water to accomplish the purpose of the reservation. The court, the Arizona Supreme Court, when it ruled on the state land issue in 2012, I think, they kind of muddied that distinction, and the way they dealt with it was whenever they used one word, they always used the other. So it's always withdrawal and reservation, or
Yeah.
reservation and withdrawal.
Yeah, and that really is a good point, because when you look at the Federal Land Policy and Management Act, that is another example of where the legislative bodies have confused the withdrawal and reservation, and in the Federal Land Use Policy and Management Act, they use reservation for everything.
Right.
Yeah.
And so I don't know now whether there is a difference. I mean, just the custom and usage seems to be that the two are interchangeable.
Well, I think that probably
But
if you
that
look
bothers
back
me, just so
prior
you
to 1976,
know. Footnote.
maybe that that you could start making that distinction in cases that you read.
Right.
Yeah. Well, let's talk about, we've alluded to the Arizona stream adjudication, and this was one that started with the creation of the San Carlos irrigation project in Coolidge Dam that created the San Carlos Reservoir. Within the materials that we've posted for the course is an article that was written by Shelley Dudley, and that really contains an excellent history of the San Carlos project. The project itself was intended to deliver water to the Gila River Indian community, and the idea was that there would be 100,000 acres for the Native American tribes, and 100,000 acre to what was referred to in the case as the white users.
The white men.
Yeah.
White lands.
And this created really an Indian reclamation project, the San Carlos project. And in order to do this, we had to make or to designate who had rights along the Gila River. And so an action was filed in federal district court that under the number of Globe Equity number 59. And the result of that case that came out in June of 1935 was a long list of those individuals and entities that had rights of use on the Gila River. I think that one of the things we're talking about now is that case is still alive.
Yeah. the ink wasn't dry on the decree before they started litigating different issues. And as you know, it's not very easy to understand that decree. It's got a lot of conditions and terms in there that I think are subject to different interpretations, but that's the operative document that controls, the diversion of water from the Gila, beginning in New Mexico all the way down to, I think, I can't remember the name of the community now, where the Santa Cruz comes into the Gila. St. John's.
That's Avondale?
No, I can't remember. But
Yeah.
but anyway, it's the major reach of the Gila through Arizona up
Oh, that's right.
until,
Well, Avondale is where the Gila and the Salt.
right. No, this is on the
Yeah,
Gila, and
so, yeah.
kind of the slew, what's left of the Santa Cruz.
But the
And they're still litigating.
yeah. Well, it's interesting. There was a new law review article that was written by Professor Joe Feller that is in their materials, and he calls it the adjudication that ate Arizona water law.
Right.
But the
So Globe Equity didn't answer other questions like, and just so you know, there are a whole bunch of other decrees, Benson v. Allison. A lot of them pertain to the management of the Salt River.
yeah, well, the Kent decree was
The Kent
was
decree is
another
another one.
one.
So you have to be kind of careful when you go into some of these areas. There's a lot of them kind of in the Little Colorado River area. There's, I don't know, 3 or 4, maybe more than that. But so some of those waters are subject to some sort of ongoing management by sometimes a judge, sometimes a water commissioner. And there's an open issue, I think, about how those decrees will someday be integrated into the general adjudication decree if we ever get that far.
Yeah. Well, let's talk a little bit about the general adjudication decree, and I think that one of their big problems has been to try to draw the hydrologic line between surface water and groundwater.
Right. We went through, I don't know, 2 or 3 weeks of hearings in the late 1980s. That also included a field trip up and down the San Pedro. San Pedro was kind of designated as a test case for some of these issues. So initially, the adjudication was handled by Judge Goodfarb, who administered it. We had a special master at that time, still do, but a different master. Judge Goodfarb, after these hearings, came up with what we called the 50% 90-day test. So he would draw this bright line along and generally parallel to the thread of the San Pedro. And if you were outside, in other words, up gradient from that line, that meant, or if you were right on the line, we'll do it that way because it's easier. After pumping your well for 90 days, if 50% of the water was deemed to come from the river, then you were subject to the adjudication. And of course, everybody went nuts over that, and we all appealed it, and the court threw it out because it's pretty arbitrary. I mean, you draw a line, and it's 50% 90 days. If you're 2 feet this way, you're in. If you're 2 feet that way, you're out. And so then we went back to a different second hearing, and we came out with a much broader subflow zone. So we would have been better off just, I think, shutting up and accepting the 50% 90-day test, but that wasn't what happened.
But I think that what we're coming down to is really more of a geologic test.
Right.
In determining how you define the cones of depression.
Well, there's 2 aspects now, and it's taken us from 2000, if I remember the date well. It's 2000 until, so what's that, 18 years. So this is kind of where we're at after 18 years on the San Pedro. The subflow zone is the saturated Holocene or recent alluvium. Holocene alluvium is that's been deposited within the last 10,000 years, generally.
Essentially, since the last ice age, we've had the washing down into the valleys.
And Goodfarb's second opinion, which was, again, affirmed by the Arizona Supreme Court, it said it had to be saturated, but DWR can't tell. They can tell you where the boundary is on a map between Holocene and non-Holocene, but they can't tell you whether that Holocene is saturated at depth. So the second judge, he just said, well, we'll forget about the saturated part. So basically, you have the Arizona Geological Survey out there delineating or depicting that zone of Holocene alluvium. If your well taps that, gets its water from that, then you're deemed to be pumping surface water. If you're outside that, you still may be subject to the adjudication process if the cone of depression from pumping the well extends to and intersects that boundary between the Holocene and non-Holocene. And the extension doesn't have to be very much. It's 1/10 of a foot, which is roughly an inch. So through some process, probably numeric modeling, at least that's what the courts directed recently. If that numeric model shows that you're causing a decrease in the hydrostatic head in the aquifer at that boundary of an inch, then you're within the court's jurisdiction. And I will tell you from my days as a hydrologist, you can really construct a model that includes probably 90% of the wells in Arizona. So we're kind of back to some of the things that Professor Feller said in his paper, that maybe we're better off just adjudicating everything and figuring out how to manage it. But of course that raises all kinds of policy decisions. So we're kind of full circle back to, how are we going to do all this? And I don't know. I don't see an end in sight.
But I think that as you describe what is going to be considered surface water versus groundwater, it really is a technical distinction that is going to be very difficult for a small user to make that determination. Just
to put a gloss on it, it's very difficult to construct a numeric model that can be calibrated and validated and accurately reflects the real world. It's probably a better technique than some of the what I call the mathematical models, that are based on equations. But it's still not something you do overnight. Mm-hmm. So, some of these AMA basins, they've been working on models for years, trying to get them to run, and they're further along the path, but they're not done yet. So when the court says, well, we need to go construct a model of the San Pedro and we'll figure all this out in that context, I'm looking at the calendar and thinking, I'll be retired by then. I'll probably be dead by then. What do I care, right?
But I think that so much of this, since you are dealing with the technicalities here, you'd almost think that you could, if you ran a geophysical survey along your what would be considered sublow zones, that you come up with a model based on a geophysical survey as opposed to other options.
Well, what they'll do, it depends on the area, first of all. But they break it into basically cubes that have hydrologic parameters and different layers. Mm-hmm. And then they run all that stuff and they try and get it to balance. And so it's not an easy process. And the 1/10 of a foot is a jurisdictional test, so it means you're in or out, but nobody has answered the question, what happens if you're in? Because what if you're in, but 99% of your water is deemed to come from outside that? Maybe you're just subject to the adjudication for that 1% of the water you withdraw. Mm-hmm. And the other thing is, it seems to be a presumption, if you go back to Southwest Cotton, Howard v. Perrin, clear and convincing evidence. So, DWR's determination is clear and convincing evidence, but then the court kind of says, well, but that's just a presumption. So if you come up with evidence to the contrary, which doesn't have to be clear and convincing, then that presumption, it's the bubble bursts, it goes away. So there's all these questions that are going to have to be answered someday.
So that means that the determination of the right to use water from underneath your ground is going to be up in the air
for a long time.
For a long time.
Right. That's about the safest thing you can say.
All right. Okay. Well, Carlos, thank you very much for coming in and sharing your knowledge of this. I think that it's you know, I'm not sure we arrive at many conclusions, but at least we understand.
You never have
the problem.
conclusions in water law. You just, you don't look for logic. You just try and find an answer for the time being.
Yeah. Okay. Oh, well,
It's been my pleasure to be
Yeah.
here.
Thanks again.